This spawned out of an actual incident that happened in my community where attorney-client privilege was being abused, or the claim of attorney-client privilege was being abused to have a closed meeting, because that is one of the exceptions. And then in a closed meeting under that, you are not required to record the meeting. So, and it was a pretty egregious case that it was posted that it was going to be a closed meeting to talk about a contract related to the school district on a Friday of a holiday weekend. The school district had no idea that the contract was going to be discussed in closed doors about them without their consultation. They tried to talk before the Wednesday meeting on a Tuesday to say, you know, what's going on. Their attorney, the school district's attorney, even called the city and said, the city attorney, and said, you cannot close a meeting for attorney-client privilege, because attorney-client privilege under the state of Minnesota is only if there is an active lawsuit, and you can only close it specifically to talk about the lawsuit. If you do any other business, you have to open it back up. I think most of us know this. Or if there's a specific threat. So I'm filing in court against you tomorrow on this issue. So the school board attorney even said, we've never threatened a lawsuit. There is nothing pending. If you have this meeting, it would not comply with Minnesota state law. And a city in my community still held it. They made an official decision in closed doors. So even if you're having attorney-client discussions, anything else like an official city action should not be done behind closed doors. And then when community members showed up at the next meeting and said, what did you do? We don't think this complied with the law. The city refused to release any data on it. It went to an advisory opinion with the state. The state came back and said this was absolutely inappropriate. This closed door should not have happened. The community members said, okay, release the recording because you have to, you know, record meetings. They said, well, attorney-client privilege, we did not maintain any data whatsoever. Recordings, emails, anything, so that anyone in the community has any right to see now what went on in this meeting. As I dug further into what the community could do with this response, because a lot of people were upset, we found out that the laws had not been updated in 30 years. So a person, the attorney fees are pretty limited. So community members would pretty much have to come out of pocket to take the case to a judge to get any sanctions on bad actors. The sanction at the end of the day, if you do this 3 separate times over years, then maybe you couldn't hold office anymore, and it would be a $300 fine. And talking to city council members, and my house member carrying this with me was a city council member. He said, yes, it's so hard for anyone to meet all these standards and actually have anything happen, and then a $300 fine. We were pretty much just told, don't worry about it, because if you ever, you know, don't follow these laws, because it's impossible for the community members. And especially with the kind of death of local news, that used to be who was holding these things accountable. They would help with the lawsuits. And now it is really all on the community members to do this. So this law does a couple things. One, it says if there's going to be attorney-client privilege, you now have to state as you're closing the meeting, which you don't have to currently do, what the lawsuit is, so that they're actually having to say, yes, there is really a lawsuit, and not just like saying attorney-client privilege and then, you know, just using that as an excuse to have a closed-door meeting and not record anything. 2, it does ask them to record, and you are probably going to hear, well, that would cause a chilling effect. We wouldn't be able to have that conversation if it's recorded. But the safeguard is that is not required to be released, and we do record all other closed-door meetings. So there's already procedures in place to do this for contract negotiations and other things. And it would never be released unless the case goes all the way to a judge who would review it only in camera, which means it wouldn't even go before, you know, jurors or anything. If a judge reviews it in the context of a lawsuit, only then could it be released if it is found that the privilege didn't actually exist and was abused instead. And then finally, it allows community members a greater recovery of their legal fees so that they could even bring these cases forward, and increases the fine from the levels set in the 1990s of $300 to the first offense being $1,000. So to me, this is really a bad actor bill that, because for someone to get through all these wickets, we want it to be more than like a little slap on the wrist, which is kind of what it currently is. So that is everything behind this bill. It's a fascinating story. I don't want to tell it all now. Get me offline. I will tell you what happens. But that's where we got to how we are here with this bill.